seated, please. Two somewhat related cases for oral argument this afternoon. We'll hear oral argument in the order in which they appear on the calendar. City of Titusville versus Farmton Water Resources.
May it please the Court. Good afternoon, Your Honors. I'm David Caldavia. I represent the City of Titusville in this appeal. I would like to reserve 3 minutes for rebuttal. This appeal and the next one both arise from the same administrative licensing case in the Florida Public Service Commission. They involve an application for a certificate to authorize Farmton Water Resources to operate a privately owned water utility in Brevard and Volusia counties. Titusville contends that the PSC has made several reversible errors. Farmton contends that Titusville does not have standing on appeal. Our first point on appeal is that there's no competent substantial evidence to support a determination that Farmton complied with the applicable financial requirements needed for one of these.
Is your argument really on that issue, that there's nothing legally binding the parent corporation to meet the debts of Farmton?
That's certainly one of our arguments, Judge. They relied primarily on two affidavits that were put in evidence, which, for all intents and purposes, were equivalent to pre-filed testimony, which I'm sure Your Honors are familiar with, handling appeals in the PSC from the PSC. These two affidavits essentially said that the parent corporations had a present intent or a willingness to provide Farmton with whatever financial capital contributions as were reasonable and necessary. However, there was no evidence as to...
Okay, let me just make sure I'm clear. Are you talking about the affidavits of Schaefer and Long?
One was Long and the other, Judge, Schroeder. Charles Schroeder.
And was there not one other person that talked about the obligations of...
Mr. Underhill testified.
Mr. Underhill. And what was wrong with his testimony?
Well, Judge, what he did was just parrot back what the affidavit said. He said that the parent companies have enough financial information. In fact, I've got his transcript right here. I'll read from it for you. On pages 169 and 170 of the trial transcript, which was his pre-filed testimony, Mr. Underhill was asked, does Farmton Water Resources have the financial ability to provide the service proposed in its application? There are three types of services: residential, retail, fire, and raw water services.
Could you speak up a little bit?
Yes, Judge. I'm sorry. I have a soft voice. There were three types of water services that Farmton was to provide. And by the way, I'm kind of intervening in the testimony here to set it up, but the application provided that Farmton was going to need $5.2 million to start up its raw water system, which would be a well field, a large well field. It was going to need between $100,000 and $288,000 per year for the operating maintenance expenses for that well field, and over $500,000 for the test year to run its whole facility. Mr. Underhill's testimony was that, yes, Farmton Water Resources is a subsidiary of Farmton Management. We provided, as part of our application, a financial statement for that entity. That's their parent corporation. That parent corporation provided a balance sheet showing that it had $1.2 million of assets, substantially less than $5.2 million that they would need to come up with this raw water well field. It comes down to it, the only area where there's a possibility of some significant need for capital expenditure is in the area of bulk raw water services. That's the $5.2 million number. Under the proposed service availability policy, substantial amounts of money would be paid by the proposed customer, which would assist us in constructing those facilities. Whatever other additional capital needs exist can easily be met by the utility based on funding provided by its parent company.
Don't most utilities finance their facilities, albeit over a long period of time, by the ratepayers?
Yes, but
I
you
mean,
have,
you need some upfront money, but don't most utilities, they don't have the money on hand when they have to put in all the facilities up front.
they should, Judge. They're required to have a financial ability to provide the service, and they should
Is the
get paid.
financial ability showing the capability of collecting revenues? Can you not demonstrate financial ability that way?
Well,
I
I
did a
presume
lot
you
of
can,
local,
Judge.
I did a lot of local government work.
Yes, sir.
In the
And of
past
course you
life.
can, Judge, and you go to the bank and you show that you've got this projected stream of income, and the PSC's rules contemplate that in rule subsection 1S of 25-30.033. There's three subsections of that we're relying on, 1E, 1R, 1S. 1S provides that if there are any financing agreements out there that this utility is going to be relying on to show its financial ability, they need to present those. If they're relying on affiliated entities to provide financial ability, they have to provide the financial statements of those entities. In this case, Judge, these affidavits were relied on. We were deprived of any opportunity to cross-examine those. Let's say the evidence was sufficient. We were deprived of the opportunity to cross-examine those two folks, to confront that evidence. So even if you find that the testimony was sufficient to show financial ability, my client was deprived of due process.
Did you request an opportunity to cross-examine?
Yes, Judge. Well, the objection was made when the affidavits were moved into evidence. The objection was made that they were hearsay and that they were equivalent to pre-filed and that we didn't have an opportunity to cross-examine. I believe the record, the transcript will bear that out. If not paraphrased substantially by me. So in this case, not only did they rely on this evidence that was hearsay and prevented my client from cross-examining and confronting the evidence, but there was also.
Okay, let me back up then, because I want to understand something here. If the evidence was legally sufficient to show that the parent corporations would be on the hook if Farmington did not meet their obligations, would you have a case?
Yes, because there's still no evidence.
You're saying the parent corporations are not sufficiently funded.
Well, we don't have any evidence of what Miami Corporation's financial status is. We don't have any evidence of what Farmington Water Resources financial capability is. What we have is a statement by them in their application that they have no assets and no revenues, but they don't say anything about what their liabilities are and what their debt is. I mean, look at Enron. We can have easily a situation where the debts are.
I'm a little concerned here because, I mean, I finally picked up your argument when I read the brief for about the 10th time. And that's why I asked you what the real argument is here.
Okay.
Because it seemed to me, when I first read your argument, it seemed to me like what you were arguing was Farmington didn't come up with a financial statement, which to me seemed a little bit, let's say, absurd when somebody does not have a financial history. But then, as I kept on reading, I started getting to this question of that maybe what you're talking about here is just the financial ability.
Judges, I'm sorry to interrupt.
And I guess I'm concerned because even the other side, when they read their brief, didn't necessarily pick that up as being your argument. And I'm not sure you've clearly enough raised it. I'm not sure it's a winning point anyway, but it was sufficiently, laid out here.
Well, Judge, it's a multifaceted argument. To be honest, you're right about them not being on. We do contend they're not on the hook. They've only given an affidavit. Why didn't they provide an agreement saying that yes, we are committed to provide X amount of money? We know that this well field is going to cost $5.2 million. There's this service availability charge which I touched on, and Your Honor alluded to. That's only going to provide 60% of the startup cost of that $5.2 million facility. That leaves over $2 million. Who's going to cover that, Judge? The parent corporation only has $1.2 million in assets, and that's if they gave every single penny to Farmington Water Resources. Where's the rest of the money coming from? There needs to be proof of that, Judge, in order for them to meet their burden in this case. And they relied on a non-rule policy in this case, Judge, or a unadopted rule, as the phrase is changed over time in the case law. And that non-rule policy or unadopted rule provides that, well, if the applicant can't provide a financial ability, then we can rely on the parent's financial history. There's no rule that says that, and it's clearly an unadopted rule, and they can't rely on that. The case law is very clear. Our second point on appeal...
Just a minute before you
Yes,
get away
Judge,
from that, Earl Underhill, who is Miami Corporation's Director of Operations, did testify.
Yes, he did, Judge.
Did he give an affidavit?
No, Judge, he did not, although there's a reference to that in the final order. The final order says that he gave an affidavit, and that's incorrect, and if it means that his affidavit was put in evidence. He sponsored the affidavit going into evidence as one of his exhibits, exhibit number 40, I believe.
Yeah, but I'm sorry.
Well, he did provide evidence of financial support for the utility, did he not?
Judge, he didn't provide it. He said that, yes, they have financial ability. That was his testimony.
You didn't have the opportunity to cross-examine him?
Yes, we did, and he testified that he did not even know who owned Florida Water Resources, and he did not testify, and he said that the only agreement that he knew of between the two entities was this affidavit. Well, an affidavit's not even an agreement. So I believe that we did cross-examine, but I don't think they met their preliminary threshold of meeting their burden of proof on the financial responsibility or financial capability aspects. Our second point on appeal, Your Honor, is that there were numerous procedural problems in this case, material procedural problems affecting due process. This proceeding is governed by Chapter 367. Chapter 367 contemplates that these types of certificates are issued by the Commission. The Commission is a 5-member collegial body.
They cited in their brief a number of statutory provisions. It seems like the chairman has the right to delegate the responsibility.
Under Chapter 350, which Chapter 350 is not the chapter that we're under. Chapter 367 specifically says that it controls over all other laws, and you'll hear a lot about that in the second appeal.
350 is a general commission chapter, is it not?
Yes, but 367 says that it supersedes all other provisions unless it's specifically overruled by the other statute. I see I'm running into my rebuttal time, but I think it's important to point out that the final order...
It's interesting you're arguing that, though, that 367 supersedes everything else.
That's what
because at least part of your argument and part of the argument in the other case is that Chapters 163 and the other...
That's not really the argument that I believe Brevard County is presenting.
Whatever the other one is, 153?
Brevard County, it's 153, but I think you'll argue that they both have separate spheres of operation. But, Judge, very important, the final order in this case bears no resemblance to the oral determinations of that board. The final order is not signed by the PSC.
Do you know we have orders of this court that go out signed by our clerk, even though the clerk is not necessarily the person to do the orders?
Your Honors are not bound by the APA or the public records, the Sunshine Law, or Chapter, or the APA, I think I mentioned that. So, yes, that's true, Your Honors don't, but this is a different situation. The Verlani case Verlani versus Department of Health is very much on point to this issue. I've cited it in my notice of supplemental authority. I'd request Your Honors to consider that. For these and the reasons cited in our brief, we would request the Court to reverse the final order. I think I'll reserve the rest of my time for rebuttal.
May it please the Court, I am Richard Belak, representing the Florida Public Service Commission, and with me at the table is Marty Dieterding, representing Farmington Water Resources, LLC, the utility applicant for initial PSC service area certification. The main theme of the appeal seems to be,
Do you intend to split your argument between you?
well, I think we're going to make a judgment based on the questions and the time, Your Honor.
All right.
The main theme of the appeal seems to be that if Farmington is certificated, then somehow that will compete with and duplicate what Titusville is doing in the area of bulk water. They don't cite any PSC case law for that, and there are decades of PSC cases about.
Can I disagree with you? Because I think the main focus of at least the city's appeal to me appears to be that there's not sufficient showing of financial capability of this utility to provide the water.
Right.
And I think my one real question goes to the sufficiency of the evidence to demonstrate that the parent corporations are on the hook to meet the financial obligations. I mean, it's hidden a little bit in their brief, but it's there.
Right.
Well, can you address that?
Certainly. The point that the Commission's order makes is that Mr. Underhill was, in fact, what's brought out in that is they're relying on a case called Duran versus HRS. The HRS employee in that case didn't know anything about Mr. Duran's finances. She didn't have any personal knowledge. She had a bank statement that she got in the mail, and that wasn't sufficient for the agency to hold that Mr. Duran's finances exceeded the threshold for HRS to subsidize him. The difference here is that Mr. Underhill has been managing this property for 25 years for the Miami Corporation and testified that he did have personal knowledge of the financial condition of Miami Corporation. He did know for a fact that the corporation owned 50,000 acres of land free and clear, and that there was no doubt whatsoever that they could finance this utility. He did point out that they didn't expect there to be large expenditures because under the service availability provision, most of the cost is handled by the customer for the bulk service.
Yeah, I'm not sure I have a problem with his testimony. I mean, the other side argues that, and I'm not sure that's, as far as the financial capability, the financial capabilities of the Miami company. But what concerns me a little bit is if Farmington, the actual applicant here, doesn't meet their financial obligations, is there sufficient evidence in this record that the other people will be on the hook to meet those obligations?
Right. Well, the Commission was satisfied by the testimony of record to the effect that the CPA of the engineering firm testified that she considered the affidavits to be the equivalent of written agreements. The reason there was testimony there were no written agreements is because there was no document with the title on it, written agreement. But the affidavits, the testimony of the CPA was that she considered those to be the equivalent of written agreements, even though they didn't take the form of a multi-page written agreement. So also the Commission cited cases discussing the vested interest of the parent in the viability of the utility. From the Commission's standpoint, if they don't meet their obligations, they're regulated entities. They'd be fined. And everything, they'd be subject to penalties. And everything on the record indicates that Farmington, the parent corporation, Miami Corporation, has a very, very large interest in the management of this property through this utility.
Yeah, I guess the city would argue back to you that, well, it's fine and dandy that the Public Service Commission can fine Farmington, but if Farmington goes out of business, somebody has to provide water service there, they're scared they're going to be the ones going on the hook.
Well, the thing that's a little bit unusual about this project is that the need is going to accumulate over time. So then you have to make a judgment how many dollars are in the subsidiary for the amount of construction that's going on at the moment. The bulk water thing may never be built. These are projections down the road, but it doesn't mean that the money has to show up in an account at any given time until they need it. But there were, the important thing is that even if the affidavits were hearsay, they supplemented and corroborated Mr. Underhill's testimony. And Mr. Underhill's testimony can't be written off as parroting the affidavits, because he testified, unlike the HRS employee in Durand, he testified from his personal knowledge on the basis of 25 years with that corporation. Now, they haven't cited any case that says that if a witness sponsors an exhibit, the witness has to be the author of the exhibit, or that the author of the exhibit has to be on the witness list so that author can be cross-examined.
Wait a minute. If the affidavit is being offered for the truth of its contents, it's an out-of-court statement. It's hearsay.
That's true.
And how does it even come into evidence?
Well, we didn't say there wasn't hearsay. What we said was that under 120.57C1, hearsay is acceptable in an administrative proceeding so long as it corroborates and supports non-hearsay testimony. And what I'm trying to say is that Mr. Underhill's live sworn testimony before the commission, based on his 25 years of involvement with the Miami Corporation, can't be written off as the equivalent of the HRS employee who had no personal knowledge. It's two different situations. We didn't say it wasn't hearsay. What he testified to was...
Yeah, I go back. I mean, again, I hate to beat a dead horse, but I think this is really the only viable point here. Did they sufficiently raise the question of whether there was a sufficient legal hook to hold the Miami Corporation and the other Farmington legally responsible?
Well, what we have in the record is the CPA's opinion that that was the equivalent to a written agreement.
CPAs give legal opinions?
Well, in
Are they competent to do that?
her experience, she believed it to be the equivalent of written agreement. So if she were asked, was there a written agreement, she said, as a formal matter, no.
Was there an objection to that testimony? Is it beyond her competence?
Not that I recall. As far as the claim that the commission didn't comply with its own rules, they're simply putting into the rules additional requirements. They're imagining them into the rules. And then assuredly, we didn't comply with their imaginary amended rules. And it's very clear, and we pointed this out in the brief, those rules are structured that way for a reason. There are two classes of applicants for original certificates. The utilities that have operated previously, often they provide a service for free. Now they want to charge for it. They've got to get an original certificate. They've got financials because they've operated maybe for 25 years. So we can get their financials. That can be the statement demonstrating their financial ability. But it's important that sub E of the rule doesn't say what form that demonstration has to take. And there's another class of applicants, like Farmington. It's never operated. They don't have financials. That's why the rule doesn't say you have to give us a statement of that demonstrates your financial ability, and it has to take the form of your own financials. That would be the law requiring the impossible. That's how they've amended sub E of the rule. The way they've amended sub R of the rule is an absolute requirement that we get the financials of the applicant, whereas sub R of the rule says we want them if they're available, because we can use them for rate making. If they're available. They've decided to read the phrase if available, which occurs twice in that rule, out of the rule. So they've amended it into an imaginary rule. We agree that we don't carry out their imaginary rules. They amended S into an imaginary rule. S says we want the financials of every affiliate that you intend to rely on for your funding. Farmington, in its application, intended to rely on Farmington Management. We got those financials. They complied with the rule. Then we said, we're not satisfied with that. In this particular set of circumstances, The Miami Corporation has been around for 75 years. These other subs are new entities. In addition to what we've got, even though the rule doesn't require it, we want a pledge of funding support from Miami Corporation because they own the land. And they gave us that, not because the rule required it, but because we asked them for it. We wanted that additional comfort level. So no, we didn't carry out their imaginary amended rules, but we don't have to. And those are all of a piece with the rest of their claims. They said that the commissioners didn't do their job, that they delegated their adjudicatory roles to the legal staff, and the proof of that was that the commission's order looks like the staff recommendation. They said almost verbatim. Well, even if they didn't read the Shimek case, they must have read Harloff versus Sarasota, because that's their water management case, which has nothing to do with the issues on appeal. But the interesting thing is, procedurally, the main issue in that case was the Harloff court said that's fine, that the Water Management Board issued a final order tracking the legal conclusions of its expert staff, even though they had to overturn an intermediate hearing officer to do that. In the commission's case, the commission panel is the hearing officer. It was even easier for the commission to do it. But they must have read the Harloff case, and the Harloff case says there's nothing wrong with it. So they're attacking the commissioners just to attack the commissioners. Same thing with the agenda packet attack, trying to leave the inference that the commissioners voted without reading parts of the record that weren't in the agenda packet. Well, they quoted liberally from the commission's website, so they either knew or should have known that all of those items were posted on the commission's website as soon as they were filed with the clerk's office. So the commissioners didn't have to wait till a week or 2 weeks before the vote in order to have access to all of those documents. These are all baseless, meritless claims, and there's a mountain of them, trying to give the appearance of merit where there's no merit from the sheer number of claims. Far, far more than in the usual appeal. They even claim that they have testimony from one of their witnesses, Renetta Curry Grant, that they're going to be forced to buy Farmton's bulk water if Farmton's certificated. But she rescinded that testimony on page 219 of the transcript and replaced it with the idea that their options might be affected. And it's true. If Farmton goes to the Water Management District and presents more attractive options to the Water Management District than the city does, their options may be affected. But that doesn't mean that this warrants a lobbying campaign to try to interfere with the jurisdiction of a different state agency, the Water Management Board, or to try to keep Farmton from going to the Water Management Board and presenting those options. And to conclude on that point, what they're really unhappy about, what really injures them, is the regulatory scheme. They don't like the idea that a private utility as well as the city can go to the Water Management Board and present options. And that doesn't create standing. That doesn't create appellate standing. And they're worried about their plan under Chapter 163, but 163.3211 says that nothing in that act is intended to withdraw or diminish any legal powers or responsibilities of state agencies. So to lobby the court to get on board with their effort to block access to another state agency with a mountain of meritless claims is not a reasonable appeal. And as the City of Mount Dora case said, which they cite for other reasons, it says that though the PSC has no regulatory authority over municipal utilities, that doesn't mean that municipalities can interfere with private utilities' prerogatives. And that's truly what this appeal is about, trying to interfere with the ability of Farmton to invoke the jurisdiction of a different state agency. And if they're injured by something, it's the regulatory scheme. That's what's injured them. And they have no appellate standing to complain about that, and it does not demonstrate any error whatsoever in the Commission's order.
response?
Judge, was there any additional time for the other appellee, or is it my time?
Time has expired.
Judge, how much more time do I have?
I
see it.
32 seconds.
Thank you. I'm going to go ahead and beat the horse one last time. There is no agreement that puts a hook on the
Well, Judge
the
Webster
two.
had a key question here. When Mr. Underhill testified that he felt that there was an agreement, was there an objection raised?
Judge, I'm not going to tell you I remember that one way or the other. I'm going to urge you to look at the transcript, because it was certainly developed that this was not an agreement, whether it was in the form of an objection or whether it was in the form of drilling cross-examination. An affidavit is not a contract. We all know that here. It's not supported by any consideration.
But the CPA apparently wasn't claiming it was. The CPA was saying it was, is it a her or him?
It was a her.
Yeah, that's what I thought. In her opinion, it was, for all intents and purposes, the equivalent of an agreement. And if there was no objection to that testimony as beyond her competence as a witness, it comes in and can be considered just like any other
Well,
testimony.
my response to that, Judge, is that I know for certain is argued in the briefs, the post-hearing briefs, that this was not a contract. It was unenforceable as a contract. I believe that it was argued at the hearing, whether it was in the form of an objection or
But see,
it's been a while.
what's critical to preserve this is not that you argued that it wasn't a contract. What's critical is that you argued this witness was not competent to offer a legal opinion about what that affidavit amounted to. If you didn't do that, it's not preserved.
Do I get to respond?
Yes, go ahead.
Judge, if I can't tell you I remembered if there was an objection or not, but I will say this. If a witness takes a stand and says that I looked out in the sky today and the sky is red when it's blue, it doesn't matter whether there's an objection or not. If it's not competent, it cannot
Of course it
support.
matters. Of course it matters.
I would disagree.
I
Your Honor.
respectfully disagree with you. It does matter. If you don't object and raise a proper objection, there's no error. Because the trier of the case below has never been given an opportunity to correct the error.
Well, I believe the opportunity was there. I believe the record will speak to that, Judge, although I don't have a specific recollection. The transcript will speak for itself, and I'm sure it'll satisfy you that this issue was certainly preserved. And I appreciate Your Honor's time today. Thank you very much.
Thank you.